Namaste, Sakshi Telugu Prajala Mana Sakshi. Welcome to special immigration show. Today we are back with our expert attorney Prashanthi Reddy from Law Office of Prashanthi Reddy PLLC. And if you have any queries regarding immigration, feel free to call us. Our attorney will be glad to answer your questions. And also make sure that your questions should be related to today's topic. And so before we begin the show, please note that the information provided on this show not a legal advice, just for information purpose only. So Sakshi TV or its agents will not be responsible for this. If you need any specific legal advice, please contact the attorney directly. And today we are going to talk about how to respond H1B RFE. So without any further delay, let's begin the show. Hello ma'am, Prashanthi Reddy garu, how are you?
I'm good, thanks. How are you?
Yes, I'm doing good. Thank you, Andy. Welcome to the show. Please, Prashanthi garu, can you please provide information on law offices and also practice areas?
We practice immigration law, and my website is www.reddyesq.com.
Yes. Thanks for the info. In previous episode, we are discussing about H1B and change of status from OPT to H1 and also F1 to H1, right? So today we are going to talk about how to respond to H1 RFE. First, I just want to know, what is RFE?
So basically, RFE stands for request for evidence. Yeah. So whenever they want, once you file your H1B petition with USCIS, sometimes they're not satisfied with the documentation that you provided. The documentation is not enough to show that the person qualifies for the H1 or the position qualifies for a H1. So they send something called a request for further evidence, which an acronym for that is basically RFE. So it's increasingly common to be getting RFEs in the recent past, especially 2018, 2019. About 60% of the cases were RFE'd. So it's important to know that term.
Mm-hmm. Right, Prashanthi garu, we have a caller, Andy. Abhijit, please go on.
Hi, can you hear me?
Yes.
Yes, go ahead.
Hello. Yeah, hi, my name is Abhishek. I'm calling from Houston. I have a question. So this is regarding the H4 and H4 EAD. So my wife, we have applied for H4 and H4 EAD, and it is still under process. My question is that, can we travel to outside US to India and then come back? So once we travel to India, we will get a H4 stamping while coming back, and then so will it disturb the H4 EAD process?
No, but a lot of people are asking this question because they think that by somehow traveling and coming back on a H4, the EAD somehow will get approved faster. So if that is your purpose of doing it, I mean, H4 EAD is a separate application completely from your H4 application. So even if your H4 application gets approved, it doesn't mean that follows, the H4 EAD follows. So the delay here is really not with the I-539 H4 application, but the delay is happening with the H4 EAD applications, the I-765. Completely separate forms also, just separate fees, separate receipt, everything is separate. So the delay is happening with the 765, which is the EAD cases. So yes, you can travel and you can come back as long as it's an extension that you filed for and not a change of status. If you filed for a change of status, then that change of status part, I mean, basically your H4 will get denied, and since the H4 EAD is tied to the H4 in that sense, the H4 EAD also will get denied. But if it's an extension, then traveling outside the country will not in any way affect your H4 EAD. But when you travel and come back, then you will obviously have a new I-94, and you might have a different date also of approval. So that might trigger an RFE if they see that there is travel, and they might ask for the latest I-94. But as such, your H4 EAD should not get denied because you traveled. But also it doesn't mean that the H4 EAD will happen faster. So the time period, I think, will be the same.
Okay. Right. So so basically right now my application is still on. Like I've already filed for H1 and H4 EAD. You're saying I can still travel, and it's just that it will still continue the same application.
Correct.
Okay.
As long as it's an
Thank you.
extension, please remember that.
Yeah. So there are two separate applications. I know, 539 and 765.
Right, but the
So
539 has to be an extension, not a change of status.
Correct. Yeah. So H4 it will get extended, and then EAD will it's a work authorization.
Right.
Right. Thanks for calling. And so, Prashanthi ma'am, what should we do if we receive an RFE from USCIS?
So if you receive a RFE, obviously we have to respond to it. It's a request for further evidence, so we have to submit documentation depending on what they're asking for. So what is important is to first read the RFE carefully because you only get one bite at the apple, one chance to clarify or submit whatever documents that they're asking for. So you should read the RFE carefully and see what they're asking for. You have to review it carefully. So sometimes it's not immediately clear as to what they're asking. Sometimes they speak in riddles, USCIS. It's not black and white. They're saying that you need to prove XYZ, but they won't tell you what documentation you need to submit to prove it sometimes. Or sometimes they'll tell you some documentation, but there might be alternative documentation that you can submit to prove the same point, right? So you have to first read and make sure, and read between the lines as well to see exactly what they're saying. So a thorough review of the RFE is very important to start off with.
Okay. So how much time does USCIS allow to file a response?
About 60 to 80, 85 days, depending on the RFE, but usually they give the maximum period of time. And now with COVID, the good thing is that you're automatically given automatically 60 days more to respond. So just add 60 days to the last date that's mentioned in the RFE, and you should still be good. And that is only for RFEs that have been received as of until March 31st, 2021. They have extended until that time. So anything that you receive in April, you won't have that 60 days grace unless they extend it again.
So I just want to know, can we just ignore if we can't respond?
You can ignore it, but then you
have
can,
any issues further?
Right. The case will get denied if you ignore it, most probably. Unless you don't ignore it at any point of time. Just say it's better to respond even if you don't have any documentation. What you need to say is that you would like to go based on the documents that were already submitted, and you can give an explanation as to why you don't have additional documents and why you think that as per law they're not needed. It's not necessarily that whatever USCIS says is the law. Law exists as it is, and USCIS only interprets and follows the law. So if you disagree with what USCIS is saying and they're asking for some documentation, instead of ignoring it, which will lead to a denial, you should at least respond and tell them why you don't have the documentation or you think the documentation is not relevant to that RFE. And if you're correct, you'll still get the approvals because then the RFE is looked at again and is looked at by a supervisor, and the person sending the RFE might have made a mistake. So since, as I said, you have only one bite at the apple, don't ignore it completely. Even if you don't have the documents, respond to it with some kind of a response, the best that you can do.
Okay. So after we file the response, how long does it take for the USCIS to render a decision?
USCIS can take any amount of time. If it's premium processing, usually they should take, now with the new premium processing rules, it used to be 15 days, but now about a month, 30 days to respond. Though they are not bound by the 30 days, usually takes about 30 to 45 days. But we have seen where after we have responded to RFEs, it's taken 6 months also for them to respond. It's taken 10 months. Sometimes it's taken a year and a half when the case goes into some kind of if they have to do some secondary checks or something happens. That's unusual, but it has happened where, the RFE, we have responded to an RFE and for more than a year we haven't received a response. So that's possible. But in general, they should take a few months, even if it's not premium.
Okay. So what are the chances of approval after RFE?
Well, it's difficult to say, but I mean, there are statistics, of course. as to what number is approved, what number is, RFEs. So that's based on the statistics, the 2019 statistics. 2020 statistics are still not available, or I haven't seen them. But the 2019 statistics is when there were a lot of H1 RFEs. So about 60% of the cases would be issued RFE. And out of that, a big number, which is basically another 60% or 50 to 60% would get denied. So there was a very high rate of RFE issuance and a very high rate of denial. And this was mainly because, the majority of H1s are used up by the IT sector, and they were being very stringent with IT companies, and they were denying cases based mainly on right to control, or they were denying it based on the fact that they could not show an employer-employee relationship, especially when the employee was working at the client side, which is pretty much most of the time in the IT scenario. So thankfully, last year we had the RFEs were much less, number one, and the denials also were almost, very, very, very few, I must say. So hopefully things will go back to normal this year completely, and it will be what it's supposed to be, which is basically 80% should get approved.
So does RFE gets rejected?
Yes. So if you send the RFE doesn't get rejected. I mean, what happens is the case will get rejected if an RFE comes and you send documents and they are not satisfied with the documents that you send, or you don't send documents and you send an explanation, they're not satisfied with that, or you don't respond at all, then for sure, the H1 can get denied. Yes. So you're losing all that fee that you paid. Maybe the person will lose their status depending on what status they're on. If you filed a change of status for someone who's on a visitor's visa or some other status, and they filed and then I-94 expired after the H1 was filed, now they're only dependent on the H1 for their status. And if that gets denied, then they have to pretty much leave the country immediately. So there are a lot of consequences to denial. So you want to try and avoid a denial.
Okay. So my question is, can a beneficiary directly respond to RFE?
Yes, a beneficiary responding. Yes, beneficiary cannot respond to an RFE because basically a H1 is a petitioner-based, employer-based petition. So, like for example, if you are the employee, you cannot file a H1 yourself. You have to have your employer file the H1. And then if there's any correspondence that has to go back and forth, even if you have to find out status on your case, the employer or the attorney has to do that because they will not talk to you. And also it follows then if a RFE response has to be sent out, they will not accept something sent out by you. It has to be sent out by the employer. It can be that you write a letter. If the question is about your status, you can write a letter to USCIS saying, this is my status, these are my duties. They'll accept a letter from you, but the response itself has to be sent out by the employer.
Okay. So Prashanthi Reddy, can you please explain what are the some reasons for why RFE is issued?
Yeah, so it could be issued due to various reasons, right? So the reasons can be, as I said, varied, and I'm just trying to figure out where to start. But first of all, it could be that you don't qualify itself. So, for example, you have a job as a programmer analyst or some IT job, but you have a bachelor's in political science or some bachelor's that is not related at all to computer science. You obviously don't qualify to do the job also. So if you file such a H1, there will be an RFE and then there will be a denial. Unless you're able to show that in addition to your political science degree, you have 12 years of experience or many years of experience, and which the experience itself is equivalent to a bachelor's degree. So that's possible. But even those cases, unless the basic degrees at least closely, somewhat related, they might still deny it. But it's possible to qualify based on experience only. So that's one reason why someone can get an RFE. The second reason is whether the employer has a job or not. So you can't file speculatively for a H1. You have to show that a job is available. So for example, if you're an IT company, again, going back to IT company, you can't just say that, okay, I'm filing for XYZ and then I will look for a job for this person after the H1 gets approved. You can't say that. You can't market the person after the case gets approved. You have to show as of the date of filing, if you are a consulting company, that you actually have a PO. So that's very important. They look for that to see if it's a frivolous filing or a speculative employment or you actually have a job. So that could be the second reason as to why it is getting denied. Third reason could be that it is an IT position, you have a computer science degree, but maybe the job itself doesn't qualify for a H1. So not all jobs qualify for H1. For example, they've said in the past that even in the IT jobs, like if you send out a H1 for a computer programmer, they said that it doesn't qualify. They're saying computer programmer doesn't qualify for a H1. So we've stopped using computer programmers because it's just easier not to use them rather than argue with USCIS that it qualifies. So if the job itself doesn't qualify. For example, there are some other positions like computer help desk, which clearly, doesn't qualify. And you put in a job for a computer help desk kind of person where it's clear that you don't need a bachelor's degree for that position, like an associate's degree or even just 2 years of experience is enough. And if you file such a H1, even within the IT sphere, the case is obviously going to get denied. So you have to research whether the position meets the requirements. Sometimes it might be borderline. So you might, for example, computer programmer, you might say that, okay, I understand that you might think that in general, computer programmers, maybe an associate's degree is enough and you don't need a bachelor's degree. But my computer programmer, I need a bachelor's degree. And then you have to show from the job duties that it's so complex that a bachelor's degree is required. So then the onus is on the employer or the employer's attorney to show the complexity of the job and the details of the job. So if you don't do that, and if you use a job title that is kind of on the border, then your H1 can get denied based on that as well. Another reason could be that you have not followed the requirements of a H1. So, for example, you have to pay a certain prevailing wage, and you put a lower prevailing wage in the petition. I don't know why you would do that. Sometimes it's just a typographical error, a mistake. So that could cause the denial, and they'll ask you to again refile the LCA, etc. If you don't have a proper LCA approved, LCA is Labor Condition Application, which is a document that you file with the Labor Department before you actually file the H1. So this LCA is important. So if you have a bad LCA with a low level wage or with you're not actually showing the place that they work, you put a different work site and not the work site that they're actually going to work at. That LCA is not good. So they're not going to approve that case. They're going to say refile the LCA and refile the case. So that could be also a reason. So you have to be careful. And sometimes if you mention the wrong client on the LCA, the wrong address on the LCA, so sometimes the company name is misspelled. So any of these reasons, sometimes you ask on the LCA you only have the LCA for 1 year and you ask on the H1 for 3 years. So there's a mismatch.
Yeah.
So any of these reasons, LCA-based reasons, you could have a denial of the H1. Now there's something also called rejection, which is not a denial. No officer is looking at it. No one looks at it. There's no receipt. They just send it back from the mail room. And sometimes that can happen as well. And that's not a situation where there is an RFE or anything. It's sent back from the mail room because you don't even meet the basic criteria. You have not signed the application. You have not included a proper check. So these are the reasons why you can get denials. Also, if you have not maintained status, that could be another reason why your H1, at least the change of status portion or the extension portion, can get denied. So these are many reasons. There are also reasons with reference to wage levels. So they're saying, recently they've said that if you use wage level 1, so there are 4 levels, level 1 to 4. And so they're saying if you use wage level 1, we will deny your case. And they've been denying some cases. In the past they have. So that could be a reason. So USCIS keeps changing its interpretation. So we have to make sure that we keep up with what USCIS expects and try and, file cases accordingly. Otherwise, and that way you can avoid denials. Otherwise, you can, a good attorney or someone who has experience within the employer's office should be able to predict, with some certainty as to whether the H1 will get approved or not.
Yes, Prashantika, we have another caller, Anil from Australia. Anil, please go on.
Yeah, hi. Hi, ma'am. Good morning. So my point is, I was denied the H1 earlier, almost 6 years ago. The reason is they asked for further documentation, but the employer did not provide the documentation. I did not know about it, but finally I got a denial. After that, my status is changed. Now I am an Australian citizen. So my question is, for example, if I want to go back to US now, how that is going to impact? Is there any my past denial impacts?
No, it won't affect you. And now you have another way. You can even come on an E2, right? So you have 2 ways of coming now. You can come on a H1, but you have to look into whether you are subject to the cap now, because if it's been more than 6 years since you worked in the US on a H1, you might be subject to the cap again, and then you'll have to file under this cap or the next year when the cap opens up again. So a previous denial does not affect your case because, as you said, the denial could be because of documentation that your employer did not provide. It does not speak to you. Sometimes it might speak to you, but in this case, it wasn't. It wasn't your fault. It wasn't some shortcoming on your part or your degrees or your education. So it will not affect your further applying of the H1. But as I was saying, you can file through E2, which is much easier. And there's less stringent and less restrictions on an E2 when compared to a H1.
Oh, thank you so much, ma'am.
You're welcome.
Thanks for calling. And so, Prashantika, generally, usually we get RFE once, right? So, is there any chance can we get RFE twice in some cases?
Right. And Prasanna, before I answer that question, I just wanted to finish my thought on the reasons for denial of the H1, because there are so many reasons. Yes. And I just wanted to at least touch upon the ones that I remember. So definitely. The other reason for denial is, and now that it's cap season, so important to highlight that. Another reason for denial is the change of status applications from F1 to H1. Those cases get denied sometimes because the students are not able to show that they maintain status. I know I did talk about maintaining status, but specifically it's a big issue when it applies to students, especially if they were on OPT or CPT. They send usually F1 to H1s, we get RFEs. And those RFEs are quite unique for students because they ask for status if they were on, so CPT is basically they're studying and they're working at the same time. That's what CPT, curricular practical training. And sometimes what happens is they're studying in different states and they're going to university in a different state. So there's always an RFE when that happens as to how are you studying and working at the same time when it's 2 different states. So it's important to document that properly. And if you don't, then that part of that H1 will get denied, the part where you're requesting for the change of status. So also if the person has to work mandatorily for a certain amount of time on an OPT, you have to have an employer. Otherwise, you violate your OPT status. So they will ask for proof that you have worked and who the employer was, what the duration of the employment was. And if you're not able to provide those documents, that's a problem also. And the other predictable RFE we can get And this was more happening more often, I think, in 2019 and some parts of 2020, is when a person was on CPT after they have completed their OPT. So sometimes what happens is they go from one master's to another master's because they don't get picked in the H1 cap and they want to extend their status. So they take another master's. And so they have completed their whole OPT period, completed their first master's, completed the OPT period, and then they are on their second master's and they're immediately on CPT. So this is important. USCIS is saying once you have completed your OPT period of time, if you join another master's and not a higher level like a PhD, then you are not allowed to be on CPT.
Okay.
Because you cannot have two OPT periods for the same level of education. That law we know, but they are also bringing that to a CPT scenario also and saying just as you cannot have two OPTs on the same master's level, you cannot have CPT also. So they are expanding that restriction further to CPT. And there were some cases that were denied based on their interpretation of that. So if we see a lot more denials, I think that will go for litigation. But that's something to keep in mind for those folks who are doing second masters and CPTs. They might just say that and then there's nothing much to be done other than arguing with them, of course, that is not the law. But I've seen that luckily that there haven't been that many of those RFEs in our office, so we didn't have to deal with it as much, that many denials. But if they do send such a RFE, then I think that's a denial because they will not listen to whatever explanation you're giving, and then they'll have to leave the country and come back, on a fresh H1 visa. The H1 will get approved, but not the change of status portion of it. So that's also something to keep in mind with reference to denials.
Okay. Yep, sure. My next question is, so can we get RFE twice? Is it possible?
Yes, absolutely. Anything is possible with USCIS. But it doesn't happen that often. So if you get an RFE, make sure you respond to everything in the RFE. Don't think you can respond to 50% of the RFE and then they'll send you another RFE asking for the remaining 50% documents. They will not.
Okay.
The only time they will send you an RFE is if they have something new that they didn't ask for in the previous RFE. Then they might send you an RFE. Or if they receive your documents and they see something new in the documents that you sent and then they have further questions about that. So that's a possibility. So yes, you can get two RFEs, but it's unusual. It doesn't happen often, but it's possible.
Okay. So can we send additional documents to USCIS without RFE?
No,
Can
they
we?
will not. They'll throw it in the garbage. So because it's unsolicited mail and it won't reach, where it's supposed to reach.
Okay.
So even if you forgot to put something in the H1B package, you can't include that later on.
Okay.
You have to just wait for USCIS to request it. And usually, they don't deny cases without sending an RFE, thankfully. So you will get a chance to, submit those documents if they think that they need them.
Yes. So we have a caller, Praveen from California. Praveen, please go on.
Hey, yeah. Hi, Prashanthi garu. My question is,
Hi.
I have an H1B picked in 2005, but it's never been used. So just want to understand, can I use that H1 now or do I have to go to the new H1B? I'm currently in US on L1.
So if it's never been used, was it approved for change of status or was it approved for consular processing?
No, I was in India, then my H1B got picked and I have been stamped on H1B. But unfortunately, the project what have been stamped was no more existing with the company, so they have to just they did not withdraw my H1 at that particular point of time, but I got a visa stamping, but I never traveled on that H1 to US. Later,
So I guess
after some time,
I'm sorry?
Sorry. Now, after later on, I moved to a different company and they have filed me L1 4 years back. So I'm being in US on L1 from 4 years. I just wanted to see, can I use that H1 or I have to go for the new H1B?
Well, first of all, you cannot use that H1 because that H1 is with a different company, right? And you don't have that job anymore. But I guess your
Yes.
question is whether you are cap exempt or not. I think that is your question, correct?
Sorry. Yes. Away from cap exempt or not.
So if you follow the strictest interpretation of what USCIS is doing, they are saying that if you do not work on a H1, even if you have an approval, even if you got a visa, you are subject to the cap, which means that you have to file again this year or next year, whatever your situation is. So that's the strictest interpretation, and they've been saying that many times, and often we get RFEs on that. And once they say it, they refuse to budge from that position. So you are better off filing under the cap, and then if you don't get picked under the cap, then you think of filing as cap exempt and see what happens. Every officer is different, so you could try your luck. But yes, the strictest interpretation is that you're not.
Because I was just hearing that they were saying it should be within 6 years. Some say within 6 years. I was just going to some of the
correct. It has to be within 6 years.
Yeah, some of the attorneys says like they said we have done many cases which are beyond 6 years and we got successfully approvals. So my
you don't want to take that chance because the law is not with you.
Okay.
When you file something and the law is not with you, then you're taking a chance. You're hoping that somebody won't notice out there and will give you a wrong decision, which is in your favor, of course. But why do you want to take that chance? I mean, now the cap is open, file under the cap. If you don't get it, then think of other ways. Then take that chance and file it, as cap exempt and see what happens.
Okay, fine, Prashanthi Garu. Thank you.
You're welcome.
Yes, thank you for calling. Yeah. So Prashanthi Garu, how do we check our RFE status online?
If you have the receipt number, and if you enter that on the service center on the website, on the USCIS website, then it will say that RF request for further evidence has been issued, and it will give you the date that it was sent. So I think that's the best way of checking, other than, of course, calling your employer, who will get an RFE, the copy of the RFE, or calling your attorney, who will also get a copy of the RFE. And in premium processing, sometimes the RFE is sent by mail as well. You can request that to be sent by mail or faxed. Mm-hmm. So that's the advantage of premium processing, but otherwise it's sent by regular mail. Okay. And you have to be careful. Yeah.
Yes, as you said, a little bit premium processing, right? So what is the procedure for RFE premium processing?
Same procedure for premium processing. If there is an RFE on a H1, there's an RFE on a H1. The only advantage or difference in premium processing is that that case will get processed faster, because you paid that extra amount of money. And the advantage is that you might get that RFE via fax, so you might get it faster. Also, the advantage is it's easier to contact someone. You can talk to the actual officer that's working on your case. You can email them and request to speak to that officer, or email or correspond with that officer. So you have some privileges with premium processing, but the decision, it's not like you're more likely or less likely to get an approval. Decision making and standards followed is same, but communication becomes easier. So if you don't get the RFE, for example, because postal service is horrible right now with COVID, a lot of mail is getting lost, RFEs are getting lost. If it's premium processing, it's easy to contact them and get another copy. And they do it quickly, within a week. If you have to do regular call national customer service, they will say wait for 60 days, wait for 30 days, and it's hard to get a hold of them. So from that point of view, it's easier. Premium processing tries to make your life a little easier.
Okay.
Because there's, as you would call it, special access if you do premium processing.
Yes. So may I know what is the difference between RFE and NOID, Notice of Intent to Deny?
So there are a couple of ways of asking for documents. So depending on when they ask for the document, that terminology changes. Yeah. Request for further evidence is when you file the H1 and you're waiting for a decision, and they ask for further evidence before they can approve or deny your case or give that decision. Okay. So notice of intent to revoke, NOIR, notice of intent to revoke, is when they have an actual approval. That means RFE is done, You get the approval. A year later, you can get a notice of intent to revoke. Your approved H1. So that's a noir. The case is already approved. They found some information that is not good, and they're trying to find out whether that information is correct or not, and ask for further documentation and then re-adjudicate your case. This often happens when there is maybe an office visit. There's an audit, a Department of Labor audit, a USCIS audit, or an FDNS audit. You're paying the extra money for them to come and audit you after the approval. So they have these contractors come in. USCIS has hired contractors to come and visit your office or the client site and find out whether the person is working or not. So for some reason, if that office is closed or they don't find your employee there at the client site, it's possible that they can send a notice of intent to revoke saying that we visited and we didn't find this person and we think that this job doesn't exist and therefore we're revoking the case. Notice of intent to deny is similar to a request for further evidence, but they're just saying that they give 30 days to respond. And it's a stronger statement, meaning they're saying we're going to deny this case if you don't provide us these documents. And we're just putting you on notice that, we're going to deny it in 30 days if you don't respond. So there's a slight difference with the language and the chances of denial are more, and the time period given is only 30 days to respond.
Okay. So what are the reasons for application withdrawal? Suppose after RFE, some employers application withdrawal, right? So what is the reasons?
So you could withdraw, your employer could withdraw the H1 at any given point of time. They can withdraw it after filing if they have a receipt.
Okay.
They can withdraw it when they get an RFE. Or they can even withdraw it after it is approved. So there could be many reasons why they are withdrawing their case. One of the main reasons may be that the job is no longer available. And so after the case is approved, say you have the case approved for 3 years, but the project got over in 1 year, and you're not able to find a new project and amend it and change the work site and file an amended petition and keep the employee on, then you'll have to file a withdrawal and basically say that this job is no longer available and we are withdrawing the H1. If you don't file a withdrawal, then you're supposed to. So by law, if you don't, then you can be held liable for not filing a withdrawal. So most employers will file a withdrawal once the employee is either laid off or leaves. So another reason for withdrawal could be that the employee decided to move on and find another job, or the employee decided to leave the country. That could be a reason for the withdrawal. So there could be any number of reasons. While the case is pending, you could withdraw it because you get an RFE and you see that you don't have the documentation required to submit to USCIS, and you don't want USCIS to make a denial decision. You don't want it to get denied. Instead, you would prefer to withdraw it because there is a thinking that at least the withdrawal will be without prejudice. But if they deny it and they find something that you didn't qualify, or you have trying to file a H1 without having a job, then that might affect your other H1s. So it might make more sense at that point to withdraw it rather than to try to respond to it or just ignore it. So that's a very strong reason for most employers to withdraw after they get an RFE.
Okay. So I just want to know more information about premium processing service. So who is eligible to file a request for premium processing service? I mean, everybody eligible to file a request process?
Yeah, so generally premium processing can be filed by any H1B case, since we're talking about H1s. But what happens usually during the cap season, they take away the ability they can keep changing that, right? USCIS keeps changing that depending on what resources they have. So usually before the cap or just when the cap is about to start, they will take out premium processing for cap cases.
Okay.
Right now, the premium processing is available for everyone. And usually they reinstate that premium processing a little later in the season during the cap. Last time they did that. In the beginning, there was no premium processing, but after that, they slowly reinstated premium processing for H1s, for the cap cases. Otherwise, for all other cap cases, extensions, amendments, transfers, premium processing has always been available and continues to be available.
Okay. So how to respond a premium processing RFE? I mean, what happens next after submitting the RFE response?
Well, after you submit an RFE response for premium processing, it goes through the same thing. They will have to go and look into whether you qualified or not for the H1. They will look into your documentation that you submitted. As I said, it doesn't have to be the exact documentation that they asked for. They only suggest documentation that you can submit, but you can submit alternate documentation as well. So as long as, and this applies for everyone, premium processing and regular processing, as long as you show that it's more likely than not that the person qualifies, you don't have to show beyond reasonable doubt. So the standard being used here is more likely than not that the person qualifies. So that's a lower standard. When compared to criminal cases, for example, you have to show beyond reasonable doubt that the person committed the crime. It's not so with immigration. You just have to show that most likely, most probably, such a case is approvable. So, but they have been using a different standard recently, and that is again part of their whole restriction on H1Bs, trying to restrict it in as many ways as possible. And one of the ways that they were restricting it is this, changing the evidence from most likely than not to a preponderance of evidence, which means that they're changing the standard of evidence. So that we have often pointed that out in our RFEs, that we don't have to show 100% that the person qualifies. And they're saying, so I'll give you an example. In a case of say a software engineer, you don't have to show that every single software engineer requires a bachelor's degree. As long as the language shows, like there are a lot of books that can be referred to show what is the usual qualification, right? So as long as the OOH, which is one of those books that is referred to, Occupational Outlook Handbook. So if the OOH says that most employers require a bachelor's degree, but some do not, that is still enough to show that the person qualifies for a H1. But what they've been saying recently is that you have to show that all employers require a bachelor's degree, and that is not the standard. So they have to look at the right standard when they're responding, when they look at your response to the RFE. And as long as you meet the standard, the proper standard, they should approve the case. And as you said, they could send us second RFE also if they think that they need, further evidence.
Okay. So, I mean, what can we do to decrease the risk of an RFE?
Well, the ways of decreasing a risk of RFE is file a complete petition. So don't file a skeleton petition. Don't file a petition with just basic information in it. Then you will get an RFE for sure. And when you get an RFE, they will ask 10 other things other than what they need, right? And what also happens is that the chances of approval once you get an RFE decrease by 50%. But if you submit all the documentation ahead of time with your initial submission, your chances of approval increase tremendously. And they won't ask for all the other documentation that they ask for when they send an RFE. They like to fill up the pages. So they will ask for everything, which they wouldn't have otherwise asked for. Right? So it's important not to file a skeleton petition. It's important to review all the requirements of a H1 and make sure you meet the criteria for a H1 before you file. And it's important to submit documentation to show that you meet that criteria. Now, you cannot presume that USCIS will know. They will not know. Everything has to be backed up by evidence, by documentation. They're not going to know that you have a bachelor's degree simply because you said that in your resume. You have to submit the bachelor's degree. It's not enough to submit just the bachelor's degree. How do they know what the subjects are? So you have to submit the mark sheets or the transcripts to show that you have relevant subjects that are related to the job at hand. So, documenting everything, document. That's the key to having a successful H1. And it doesn't start with filing of the H1, it starts with filing of the registration. If you're filing for a master's cap case and the person doesn't have a master's degree from an accredited university or doesn't have a master's degree from a public non-profit or has from a private university but is not a non-profit. So if they don't meet the criteria of a master's cap and you file under registration cap, master's cap, you cannot change that then. So it's so important to review the documentation before you file anything. The first step is to review your documentation. Now you're stuck with a registration which has been approved and you cannot file the H1 because it should have been filed under bachelor's, not under master's. So it's never too early to review documentation. The moment you get the documentation, you should review it first, get the entire picture, get all the documents. You don't need all the documents for registration, but it's important to get all of them so that you know that once a registration comes, you're ready and you know that the person qualifies.
Okay. As we all know that, all H1B applicants are afraid of RFEs, right? So RFE means if your H1B going to be rejected. So is that true?
Not necessarily. We are never afraid of RFEs. It's a pain because there's more work involved, but we're never afraid of RFEs because it doesn't mean that if you have an RFE, the case will be rejected. Sometimes they ask for simple things which maybe we didn't provide because we didn't have them. For example, it could be that they'll ask for pay stubs, right? And maybe we didn't provide the latest pay stub because we didn't have it at that time. But we provided the pay stub from the previous pay cycle. So that's a simple RFE. You just provide the pay stub, they'll approve the case. Right? So sometimes some RFEs, when I read them, I know they're more difficult. And I know the chances of denial are more. And those are instances where even before filing the case, I knew it would be a challenging case. So it's not a surprise, but it's disappointing when you get an RFE, especially when you're expecting it. So when you get an RFE for a specialty occupation, for example, then you know this is a problematic job title, but you didn't have a choice. You had to use that job title because that's the job title. So now it's a difficult task to overcome that RFE, but it's not impossible. Okay. There's more than 50% chance of approval even in such cases. So it depends on the RFE really. Some are very simple. Your student RFEs, your OPT, CPT, which I was talking about, where you have to prove that they were actually working, they were actually going to school. Those are very easy because it's easy to prove. As long as you maintain your status, it's easy to show that you maintained your status.
Okay.
So those RFEs are easy because the beneficiary, the employee has said, yes, I've maintained my status, I have no issues. Then it's just a question of getting the correct documentation from them and submitting it. So it really depends on what the RFE is about. Sometimes you know that this is going to be a difficult one to get approved.
So Prashanthi garu, can you please share your tips for avoiding and processing delays and RFEs for our Sakshi TV viewers?
So I think everything that I said, just to be again put into simple language and short sentences, is most important tip is document your H1s properly. Do not file skeleton petitions. Review the documents. Make sure that you qualify before you file. And if you don't qualify, then find a way that will qualify you rather than just filing blindly. So I think that is most important takeaway from this is when you're filing initially, file with proper documentation and do your proper review.
Okay. So what are the roles of your RFEs in attorneys' roles?
I think the attorney's role is paramount in a request for further evidence.
Yeah.
Because while employers can file I-129 applications and H1 packages on their own, sometimes even that there's some things that they miss out. because they don't know the importance of it, or they just make clerical mistakes because that's not what they do on a day-to-day basis. So I think, it's important to outsource everything that you need to outsource to a specialist. We don't file our own taxes. I give it to my accountant because that's not my area of expertise. I want an expert to do it. Right? Same way with your immigration work. If you have immigration work, give it to an immigration attorney. Even though it might seem simple, but sometimes your responses will be wrong and there's no way of fixing it. And so when an RFE comes, it is often, unless you are used to seeing those RFEs and you have experience in immigration law, you will not be able to respond to that RFE because they don't ask for documents. Oftentimes, they don't ask for documents directly.
Mm-hmm.
They ask for it indirectly. They'll just make a comment saying that, it looks like your company doesn't qualify based on blah, blah, blah. But then they won't say anything as to what documents you need to submit. So you might just even overlook that statement because it'll be buried somewhere in, 10 different in 10 paragraphs, that one statement. And you think it's not important because they didn't actually ask for any documents. They just made a comment. So that you will only know if you have been in this field, or if, lawyers will know because they are trained to examine documents carefully and interpret, the wordings carefully. So it goes without saying that even if I wasn't a lawyer, if I had an immigration case, I would give it to a lawyer. I wouldn't try to do it myself, and especially an RFE.
Right. Thanks for the overall information, Prashanthi Garu. Thank you so much for joining us and spending a valuable time here. Thank you.
Thank you. Thanks, Prasanna.
Right. Thank you. So today's immigration show, we'll be back with next episode of Special Immigration Show. Stay tuned to Sakshi Telugu Prajala Mana Sakshi. Namaste.